Good afternoon, everybody, and welcome to today's Trails session. Today, we have Barbara Katz. She is the co-director of Family Voices of Wisconsin, and she is here to share with us on supported decision-making for adults with disabilities. So for this session, Barbara will, when it's appropriate, ask for any questions. If you want to unmute yourself to ask the questions, that's fine, or you can also stick them in chat, and then we can address them as soon as it makes sense in the presentation. So without further ado, I'm going to hand things over to Barbara. Thanks, Barbara.
Great, thanks, Lisa. Hi, everyone. Thanks for joining today. We're going to be talking about supported decision-making, and we're going to be talking about supported decision-making as an umbrella of decision-making options, including supported decision-making tools and guardianship. But we're going to sort of talk a little bit about what that umbrella of supported decision-making is. Before we start, Family Voice, I just want to tell you a little bit about Family Voices. We are a nonprofit family-run organization, and we support families around the state of Wisconsin in their learning, understanding, navigating, and accessing healthcare and community supports for their kids with disabilities and special healthcare needs. So as a family-run organization, there's 4 of us on our team, and we're each parents of kids with disabilities. And my son, Ben, is 30, and we went through this process with him starting about 13 years ago. Although I have to say 13 years ago, there weren't as many options as there are today. And so my husband and I are guardians of Ben, our son. But when we were making that decision, it was really almost a de facto decision, like, well, when are you not? The question that was asked of us was not, are you going to seek guardianship? It was more, when are you going to seek guardianship? And for us, that was sort of the prescribed path. We were never told about options. No one talked with us about options. It was just sort of this is the path you're on, and this is what you're going to do. And we didn't have enough knowledge at that point to question what options there were. And so I feel very passionate about this training, in that I think that it's critical for youth and their families to know what the options are around supported decision making, so that there are choices that can be made and an informed decision can be made, and not a sort of prescribed decision of this is the path that professionals might say this is the path that you're on. So having said that, I hope that you will leave this session today understanding what those options are, and knowing where you can go for more information. I will be providing Lisa with a PowerPoint of these slides, a copy of this PowerPoint, along with a resource sheet. And that resource sheet will give you direct links where you can go to find, to learn more deeply about a particular tool or a particular solution that you feel might be right for your child and your family. So I just wanted to preface my comments by saying that. So what happens at age 18? Well, basically at 17 years and 364 days, our children are still children, and we as parents have full parental rights in decision making and are still legally responsible for them. The next day, on their 18th birthday, they, in the eyes of the law, magically become responsible for themselves, and then are responsible for their own decisions, their own choices, and the consequences of those decisions and choices. And so those rights are essentially transfer at that day when our children turn 18, are the legal rights of sort of personhood transfer from a parent's responsibility to the responsibility of a now adult. And often we know that our kids with disabilities and special health care needs may need assistance with decision making. And that's why we talk about supported decision making and supported decision making options. So let's go back and think about the lives of our kids prior to when they're 18. And we know that making decisions is a learned skill. And throughout our children's lives, we give them options often. What color shirt do you want to wear? What flavor ice cream do you want? And as kids get older and as their capabilities increase, those decisions get more and more complicated. And so most often our kids have opportunities and experiences that allow them to make decisions and choices all along. Sometimes with our kids with disabilities, we have to be super intentional about this. And we have to be really conscious of how are we offering choices. We have to be really aware of whether or not our kids need assistance in being taught decision-making skills. We need to be very considerate of whether or not those skills need to be broken down into small pieces, and so on. And so it's really important for us to have this intent and to think about how we're going to support our children to learn decision-making as they grow up. And this practice and this sort of skills-based teaching can start when our kids are super young. You know, we start with preschoolers and move on. And if your children are enrolled in special education, if your children have other supports and services, think about as you're putting plans together, how your kids can be exposed to decision-making opportunities and choice-making opportunities so that they have a continuum of opportunities in which they can practice these skills that will then serve them really well as they become adults. So as was just mentioned, how can we support our kids in decision making? Well, include that skill development directly in their IEP, and potentially you have a goal around that, or you have some objectives that meet another goal, but skill development, decision-making skill development is somehow included in their IEP. And this might look different from year to year and as your kids grow, but it is just a great way to make sure that intentional development is being taught and is being thought about. And then what are those other opportunities, whether they're opportunities at home, in the community, in the car, on a trip, any place? Where are those opportunities where you could stop and say, instead of assuming I know what my child wants, can I give them a choice in this? And can I give them a choice where they will be responsible for the consequences if the choice doesn't work out as well as they hope? You know, as parents, I think we inadvertently influence our kids' decisions. We don't mean to necessarily, but we do it. We do it. We're busy. And sometimes we do it because it's easier. or because we don't have much time. But if we want to be, again, if we want to be intentional about thinking about the ways in which we support our children to make their own decisions and to make their choices and to continually build on those opportunities, we need to be a little bit self-reflective and say, do my kids speak for themselves? Or how often do I speak for them? Do I give them as many options as possible? And can I separate my desires from my child's wishes? So, this self-reflection can be hard. But again, if we want to be really authentic about the way we offer our kids opportunities, it is a suggestion that you might want to consider as you're supporting your children to grow in their choice-making and decision-making abilities. Now, as our young people and the families are thinking about what, if any, supported decision-making tool might be the best solution for that person or the best solutions. I do want to note that the tools that we'll be talking about can be used alongside each other. So it's not just like you choose one tool and everything else is thrown out of the toolbox. You can consider using multiple tools as one of the options also. And we'll talk about how we can put those together. But families and kids need information. At the very beginning of this, I said that my husband and I and Ben, our son, did not have this information. We were just sort of, good doobies and did what we were told. We were told by Ben's doctors and teachers to seek guardianship. So we sought guardianship and the courts agreed. And here we are 11 years later. But I would not say that we made an informed decision. And that's what troubles me. We still might have decided that guardianship was the right route for Ben, but I would have preferred if we had made that correct decision. So part of it was, as I said, a multitude of tools were not available, but also we did not know to start this conversation well in advance of Ben turning 18. We were just sort of merrily going along and thinking, well, he'll be 18 and, what's the guardianship process and how do we get there? And these notions of supporting Ben in his decision-making authority didn't come into the picture. And I regret that, because that is when we talk about an individual's rights, that is very much at the core of an individual's rights of making their own decisions and their own choices. So how can families be supported? Well, one way is to start thinking about these options like you're doing today by participating in this, by listening to this presentation. You're starting to gather information and I applaud you for that. That's great. Now take it to your family and share what you've learned and share your thoughts, your opinions and the facts, and start that discussion around your family about that assistance with decision making. And if your person will in fact need assistance, what might that assistance look like? And so good for you for doing that. So so I've been using this phrase supported decision making, and it can be used interchangeably with assisted decision making, as I've been using. But when we think about supported decision-making in the purest sense, it's basically a series of relationships, practices, arrangements, and agreements designed to assist an individual with a disability to make and communicate to others decisions about their life. So it is in some ways broader than just a choice or a decision. It's broader in that it's reflective of somebody's relationships. It's reflective of legal agreements. It's reflective of the way in which someone might not only make a decision, but how they communicate a decision. And sometimes people use supporters as communicators. And so that is something to consider and to think about. So let's talk about these tools for decision making. I like to think of them almost on a spectrum of being the least restrictive to the most restrictive. And this slide does not, unfortunately, reflect that continuum. This has them listed, but not in a continuum order. So I'll talk a little bit about this. There are two tools here where the individual with a disability retains their right to make decisions. They are effectively, they are the decider. And by being the decider, they might choose to use a release of information or consent or supported decision-making agreements. The other three tools that are listed here: power of attorney for healthcare or finances, a representative payee trustee, and limited or full guardianship, basically takes the decision-making authority away from the individual and assigns it to somebody else. So let's take the two where the person with the disability retains their rights to make their own decisions. First is that release of information or the consent. You might be used to these forms at the doctor's office, where you would sign something that allows the doctor to bill your insurance company. That's a release of information. At your child's IEP meetings, you would sign a paper to allow the IEP team to access your child's medical records or your child's therapy records or other records that are psychological records that are would impact their special education program. That's a release of information. Institutions, banks, healthcare clinics, schools have their own releases of information. So at the very least, your person, if they choose not to have any other assistance with decision-making, at the very least, I would encourage them to have a release of information or a consent form signed and assign somebody to be able to share and get information. My husband and I have that at our health clinic, is that we gave releases of information so that our doctors can share information with among both of us. And I think it's just good practice for people who have disabilities or not, to have another person identified with whom information can be shared. So at the very least, that's the least restrictive. The person with the disability continues to be the decider, makes their own decisions, but says that the institution, the school, the health clinic, the bank can share information with someone who they name. That can be changed at any time. It could be torn up at any time. And all of that deciding power stays with the individual. Another tool where that deciding power stays with the individual are these new legal agreements, semi-new, they've been around in Wisconsin for about 4 years now, called supported decision-making agreements. And we're going to be going more in depth into these supported decision-making agreements in a little bit. But what they are a legally recognized tool within the state of Wisconsin, where the person with the disability decides what they want support around, in which environment they want support, and what they want their supporter to do. So, for example, somebody who has a speech impediment and it's difficult or impossible for them to verbally communicate with somebody else, or very few people understand the way they speak, they might have a supporter assigned to be their essentially translator, their voice, to communicate their intent to somebody else in a way that people who don't know the person can understand. And so they would, but yet they might want to retain their right to make their own decisions. That might be one way that they use the supported decision-making agreements. Another way people might choose to use supported decision-making agreements would be to, for example, to actually share in that decision-making, helping the person to understand legal terms or what they're about to sign in ways that they are that are understandable to them. And so that would be another way that someone might use a supported decision-making agreement. Really, in a lot of ways, the sky's the limit as far as what kind of support somebody wants, who they are asking to support, and they can have multiple people support for different things, and in what environment. Somebody might want support in just healthcare, or somebody might want support just in finances, or someone might want support just in school. There's a whole variety of ways, or people might want support in all of those areas and one person to support them, or a variety of people. The bottom line is, with supported decision-making agreements, the decisions lie with the individual with disabilities. These supported decision-making agreements can be updated, they can be changed, they can be torn up, just like releases of information or consent. So those are the two tools where the person remains the decider. I'm going to stop and see if there's any questions about anything I've said so far.
I'm not seeing anything in the chat, so if anybody has any questions, feel free to unmute. Otherwise, we can go ahead and continue.
All right, great. Thank you. So now let's talk about those tools that where you're giving away the right to decide either on a temporary or permanent basis in either all aspects of your life or some aspects of your life. So let's start with power of attorney forms. There are power of attorney forms for both healthcare and finances. And this is where somebody essentially assigns decision-making authority to somebody else. And so for finances, that could be effective immediately when once the form is signed and submitted. For healthcare, it needs to be activated by physicians who say that the person is either temporarily or permanently incapacitated and can't make their own decisions. So they need someone to make decisions in the area of healthcare. So they're very, in a sense, narrowly defined. There's different forms that are used, and you don't have to go to court for power of attorney, but you do need to have it either witnessed or notarized. And this link on the website gives you information where you can go and actually download those power of attorney forms for Wisconsin for both finances and healthcare. But power of attorney says somebody's going to act on somebody's behalf, either on, as I said, on a temporary, time-limited basis or a more permanent basis. The representative payee trustee is a tool that's used by the Social Security Administration to where somebody is assigned to essentially manage somebody's Social Security benefit check. And so that representative payee trustee is responsible for setting up the bank account, for making sure the check is deposited, for spending the check the way that it's supposed to be spent, for doing an annual, a brief annual report to the Social Security Administration about how that money was spent. And some more information about the representative payee trustee can be found on the Social Security Administration website. And then we come to the tool of limited or full guardianship of the person and or estate. And that is the most restrictive tool that there is. You do need to go to court for this. It's the county circuit court, the probate division. And a judge needs to essentially say that somebody is incapacitated, unable to make their own decisions. And that decision-making authority is then given over to somebody with who the court determines will be a responsible guardian for what they would now call their ward. Guardianship can be limited to one, certain areas in somebody's life. It can be, and it can be permanent or temporary. And it can be for the whole, as I said, for the whole person or for the estate. With guardianship, the person with the disability fully gives over their decision-making authority to another person, to the guardian. However, Wisconsin has some provisions within their guardianship law that says that people can still keep certain rights even if they have a guardian. And some of those rights would include things like voting or getting certain licenses, including marriage licenses, or fishing licenses, and some other provisions. But within the guardianship petition that is developed and then presented to the court, there are a range of options and choices that sit within that people can make decisions about. So as I said, these tools can be used together. You can use supported decision-making with guardianship. You can use supported decision-making with representative payee trustee. You can use representative payee trustee with guardianship. You can use release forms, consent forms with supported decision-making tools. There are a number of ways that these tools can be used together, which sort of reinforces the importance of really understanding what each of these tools can do, what the power is of each of these tools, and how they can complement one another. Any questions now? Okay. Well, let's talk a little bit more about these supported decision-making agreements. So as I said, about 4 years ago, Wisconsin formalized the concept of supported decision-making, this sort of big umbrella where I gave you that sort of that definition earlier, and formalized it into law with these supported decision-making agreements. The Wisconsin Board for People with Developmental Disabilities has a wonderful toolkit on its website, which has sample agreements, has different scenarios of how these agreements can be used, troubleshooting tips, and suggestions about ways in which they can be used collaboratively with other legal tools within the state. But the process is that the individual with the disability decides where and how they want assistance with decision making. They will then complete the agreement, and I'll show you a snippet of an agreement in a moment. They name the person that or people that they want to support with that particular agreement, and somebody might have multiple agreements that talk about multiple areas of their lives. And as we talked about earlier, the supporter can assist with obtaining information, communicating an individual's both decisions and preferences, and making information and options understandable to both the person with the disability and the people with whom that person is interacting. Agreements are flexible and can be updated. They can be changed, all dependent upon the individual. And the individual, again, with supported decision-making agreements, remains the decider. So let's talk about some of the attributes of these supported decision-making agreements. And what the supporter is able to do. So the supporter can't make decisions for the individual. They can't sign legal documents. They can't bind the person with the disability to legal agreements. Those decision-making responsibilities lie with the person with the disability. The supporter's authority is limited to what the person with the disability says they can do. The person, there's no question, it doesn't come up whether or not the person is incompetent or competent. It's not an issue. It's not raised. If you think back to an earlier slide, Wisconsin law presumes competency among all people that turn 18 unless a court says somebody is not competent to act. And so supported decision-making agreements are something that you and I can use if we want, but they are designed for people with disabilities. Supported decision-making agreements are in writing. They're voluntary, and they need to be witnessed by either two adults or a notary. And as we said, they can be used in conjunction with other tools and can be taken back or changed at any time. So they're very flexible. And that's one of the attractions, excuse me, that people find with them. So here is an example of what a supported decision-making agreement might look like. Or a part of a supported decision-making agreement. And so there are places where you can check to see where they want somebody to support them. If somebody has separate supported, if somebody wants multiple people to serve as supporters, they would consider filling out multiple supported decision-making agreements, one for each supporter that they have named. And so there's a variety of things: getting food, clothing, and shelter, taking care of physical health, taking care of mental health, managing finances, applying for benefits, assistance with work. And then maybe there's some other areas in which somebody would want to have a supporter, but that listing are the most typical places where you might find that there needs to be a legal document in place so that the person at the doctor or the banker or the benefits specialist has proof that somebody is able to help somebody. And that's the point of these agreements. So before we go on to guardianship, let's sit with the supported decision-making agreements. And I'm curious what your questions are around supported decision-making agreements, if you have any.
I have a question.
Yeah.
So in trying to understand best decisions, so these supportive decision-making agreements, essentially the individual with a disability is still in charge of making all the legal decisions, financial decisions, or however it's determined. And so the role of this agreement is just to sort of assign supporters, but these supporters don't really have any authority in terms of making decisions. They support the individual with a disability to make that decision. Is that right?
Yes. So whatever the supporter, whatever the person with the disability is saying that they want support around, that is what the supporters sort of parameters are.
Okay. So for individuals with kind of more significant cognitive issues, I don't, or could you give an example? I guess I'm thinking about individuals on the autism spectrum, who this might be appropriate for. It sounds like perhaps.
Yeah, so I know people with very significant developmental, intellectual and developmental disabilities, some with autism, some with other developmental disabilities who use these agreements. I have to say that while they are legal tools and they're recognized as legal tools, there is still some work that needs to be done in getting people to understand the way that they work. So I always suggest that somebody would, who's using a supported decision-making agreement, would also have in place a tool like a release of information or a consent form, because those are commonly used forms that people are used to using and are recognized easily by a bank or a healthcare situation. But yeah, this would be a choice where even people with significant cognitive disabilities have the ability with the appropriate support to make their own decisions and choices.
Could you maybe give, I'm trying to wrap my head around, I hear what you're saying, but I guess I'm just thinking of individuals that for big
So
major
tell me, yeah, because I don't use these with my son, let's think of an example together.
I'm just trying, I mean, I love the idea of individuals with disabilities having, as much agency over their lives. That I think that's lovely, but I also, I want them to be protected too. So I guess I'm just trying to understand, like, to me, this makes sense if an individual has the cognitive capacity to make these decisions.
Right.
And I think about, maybe individuals on the autism spectrum that are minimally verbal. And I just wonder how they might, fully understand to be able to make decisions.
And if if they don't have the ability to fully understand, then this agreement might not be the right solution for them.
Right.
So this agreement is the right solution for people who do have the ability to understand and make choices. But it's important not to confuse somebody's ability to communicate as being the same as their ability to make decisions and make choices. Does that make sense? So
It does.
somebody might need support in alternative communication to be able to actually voice those if they're nonverbal, for example.
Okay. All right. Thank you.
Yep, you're welcome. Other questions? Well, let's go into guardianship. As we talked about, guardianship is a legal process. So you need to go to court, and the guardianship and the court process is essentially, it's the county circuit court, as I said earlier, the probate division. Counties differ as far as assistance they will give people in their petitioning for guardianship. And so some people will go through the guardianship process on their own. Some people will try to, might engage the services of an attorney. And it's really, again, a very individualized decision. And so what happens is an application is made. Doctors need to sign off saying this person is not capable of making their own decisions. And then there's a whole bunch of documentation that has to go to the court. The court will assign somebody called a guardian ad litem to support the person for whom guardianship is being sought as they go through the process. And the role of the guardian ad litem essentially is to serve as an advocate for the person with the disability, to make sure that guardianship is not being forced upon them, to be made to make sure that to the best of their ability, they understand that their rights to make choices and decisions are being taken away and will be given to the guardian, and essentially to protect their the individual's civil rights. The guardian ad litem will then also make a recommendation as part of the court process, will make a recommendation to the court about whether or not they think this person should be supported by guardianship. And then it's a process. If a person is awarded guardianship, they will then get papers that say they're the guardian. They might be the guardian for both. There might be one guardian for both finances and for the person. So that there might be a guardian, the same guardian for the person and the same guardian for the estate. There might be different guardians for the person and the estate. There might be one guardian for both, and then what's called a standby guardian who comes in if that person can't perform their guardianship duties. There might be co-guardians that work together. It could be an either or situation. So my husband and I are co-guardians for Ben, and it could be either one of us acting as his guardian. We're sort of interchangeable. You might then also consider naming what's called a successor guardian. So when the guardian, the standby guardian, the co-guardians are not able to any longer fulfill their functions as guardians, there would be a successor guardian sort of in the wings. That could be named at the guardianship hearing, or it could be named after the guardianship hearing with sort of a secondary guardianship hearing, if you will, just to add on the successor guardians. So that's essentially the process for guardianship. It can take 3-4 months typically to go through that process. So sometimes people say, parents have said, I don't like the decisions my person is making, so I'm going to seek guardianship. Well, know that if they have the cognitive capacity to make decisions, the court is not going to award guardianship, because their decisions might be poor, or they might make poor choices. That's not the reason for guardianship. The reason for guardianship is because the person is not able to cognitively make decisions and knowingly know what the consequences are of those decisions. And so that's when guardianship is awarded. Guardians have responsibilities. And so they're making decisions on behalf of a person. And it might be like, duh, of course, that's what a guardian does. But that's a big deal when you really think about it, when you're thinking about the responsibility of making a decision that's in accordance with the individual's likes and dislikes, wishes, lifestyle, etc. That you need to be a guardian needs to be very thoughtful and considerate of the individual as they're making decisions on their behalf. And that's essentially, a guardian also essentially acts as an advocate for that person to make sure that that person's best interests are always being represented. And whether that's in healthcare or in financial situations or signing leases for where they might live. Those are all considerations about making sure that the guardian is acting authentically on behalf of an individual. And that gets back to a bit to what we were talking about at the very beginning of this presentation, of that self-reflection of parents. Are you really making choices when your kids are little in acting in the best interests of the child, or for expediency's sake? So those would be similar considerations as a guardian. Are you truly acting as an advocate for your ward, or are you just wanting to get things done and just resolve things? And so that is, there is an awesome responsibility that's placed on guardians that people need to recognize before they go into that relationship. Similarly, guardians are responsible for protecting adults with disabilities from abuse, neglect, self-neglect, different kinds of financial exploitation, and violation of their rights. So while their decision-making rights are taken away, they still have their own civil rights as an individual. And a guardian needs to assure that those rights are still being upheld. So there's consequences of guardianship, right? And we should be, for people going into guardianship, should be aware of what those potential consequences are. It can be very intense to go into a court situation and have someone declared incompetent. Now, when my husband and I sought guardianship for Ben, we asked the guardian ad litem if Ben could be absent from the court hearing when we actually showed up. And she made the recommendation that yes, in fact, he could be, because I was concerned about him going into court and being declared incompetent. And so it is a painful process for both the parents and potentially the individual with the disability, again, depending on how much they understand. We don't talk much about Ben having a guardian or not having a guardian in regular social conversation or with potential employers or when he sells his artwork, because it's irrelevant. And we want Ben to be seen for his strengths, right? Not for his deficits. And so there is that danger of other people assuming that somebody is incapable because they have a guardian, and not seeing the person for who they are and what their gifts are. Guardianship does not, in a sense, protect people. It does not keep them safe. And that is, I think that's one of the biggest myths out there around guardianship, right? Nothing is stopping Ben from going to a bank and filling out a credit card application and submitting it. It would be the credit card not doing their due diligence to see, or whoever's giving him the application, to see that maybe this person needs assistance with decision making, and maybe, and then to question more about whether or not they have a guardian. But nothing's stopping Ben from going to do that. Nothing is really stopping Ben from going, meeting somebody in a bookstore and going home with them. You know, if Ben is out in the community and he is knowingly or unknowingly taking risks, guardianship does not keep him safe. What keeps Ben safe in those situations is having relationships with a lot of people, with having people who know him and support him and know when he's expected places, who sort of having a community around Ben is really what keeps him safe. What also keeps Ben safe are years of skill development in understanding that concept of safety and what that means. And so that is a whole other discussion. But I have to bust that myth right now that people have, that says that people with disabilities are safe in all situations because they have a guardian. That is not true. And so that's really an important thing to know. If you are thinking of guardianship just to keep your person safe, I would suggest that you think about how to teach them skills to keep themselves safe, and also how to surround them with people who will help keep them safe as well. So just had to put that out there because that is a huge myth among so many family members about guardianship. So how do you know what the best solution is? And, you know, I think with the question that was asked earlier, that was sort of at the sense of it. How do you know? It's not going to be, if you say a person functions at a particular IQ level, this tool is better or that tool is better. It's really first talking with your child to see if they understand what decision making is, what choice making is, and if they have any preferences around that. Do they want to make all their decisions on their own? Do they want to share information with others? If so, who do they want to share information with? Do they want to get input from others? If so, who do they want to get input from, and in what situations? Do they want someone else to make decisions for them? And if so, what kinds of decisions do they want someone else to make for them? Those are the kinds of questions that need to be answered before the right supported decision-making solution is identified. Talking with other families. I'm sure that you all know, as well as I know, that we get some of our best information from other families. And so I would encourage you to talk with other families and see where their thinking is, see what they're thinking about for assistance with decision making. And learning like you're doing today. Follow up with the resource sheet that will also be posted for you to get dig in deeper and make an informed decision and take your time. This is, there's no rule that says at 18 a decision needs to be made. If you're not ready to make a decision, then at the very least have those releases of information signed by your person and submitted to different institutions, but you can still take your time and make decisions. You can start with a less restrictive tool and always work your way up into more restrictive tools. It's very hard to get guardianship and undo it, because essentially you have to go to the court and say, so judge, while I was here a couple of years ago and petitioned and said my child was incompetent, you know what, they're really competent now. Judges are not going to, do that unless there's been a real change in the way somebody functions, and that doctors can then attest to that. So it's very hard, not impossible, but very hard to undo guardianship. So I would be really thoughtful if you don't think that your child is ready at age 18, or you're still on the fence and you don't know, try some of those less restrictive options before you go to more restrictive options. So with that, I'll stop and see if there's any other questions.
We have no questions in the chat, so if anybody has anything they'd like to ask Barbara, please feel free to unmute or put your question in the chat as well.
I have a question. So if I decide to go for the decision-making agreement, and if I see that it's not working after we try it, can I go for the guardianship after that?
Yes.
Even over 18?
Yes.
Okay. Okay. Thank you.
Yep.
I have a question too. You mentioned that there was guardianship and limited guardianship, that there were certain decision-making abilities within the guardianship.
Yeah.
Can you speak to that a little bit more?
Yes, so if you were to look at the guardianship forms that you would complete before, as part of your package that you would give to the court before the guardianship hearing, there are several pages of options of what I think like 2 pages of options of what the ward could do without your permission and with your permission. So, for example, we did leave Ben the opportunity to get married without our permission. We did leave Ben the opportunity to vote without our permission. We gave Ben, and then there's some things that you could still have somebody do with the guardian's permission. And so, off the top of my head, I can't think of other examples, but if there is a web link on the resource sheet that will be posted where you can go and actually look at the guardianship agreement and see. And that's something that if somebody is seeking guardianship, it's definitely important to spend time going through that agreement ahead of time to make sure, or you're very thoughtful about any rights that you might want the person to retain without a guardianship permission, and what rights are being transferred over to the guardian.
Thank you. And for guardianship, I guess one thing that's coming up for like international travel, maybe in the state of Wisconsin, people are more familiar with supportive decision-making documents, but I think internationally, maybe not so much. Do people with, does guardian impact kids or adults, being able to travel internationally with or without their parents as guardians?
Oh, I don't have the answer to that.
Okay.
Actually, sorry. I do know that Ben has a passport, and there is no indication on his passport that says he has a guardian.
Okay.
So, yeah. But as far as but we've never traveled internationally with him. And so I don't have the answer to that. Sorry.
Okay. No, thank you.
Yeah.
And just my final quick question.
Yeah.
You had mentioned, oh, this is just kind of a lot.
It's
you
a
had
lot.
mentioned it's a
Yeah.
lot. You had mentioned, so in a guardianship hearing, to request that your child not be present, because they're going to use words like incompetent and things like that. So that's something that you can request, that your child not be present?
So in our county, 13, Ben is 30, 12 years ago, we were able to do that. I think that decision lies with each county's court and their processes. We were able to do it because we specifically talked with Ben's guardian ad litem and asked if she could ask the court for that to happen. And so she agreed and the court agreed. And so, as I said, this was 12 years ago and in our county. Might that be the same now, 12 years later in all counties? I couldn't say for sure.
Okay, thank you.
Yep. This is, oh no, I was just going to say, I just wanted to wrap up by saying, you know, this is a lot. It's emotional. It's intense. And it's important. And it's important to not only, and I think to not only come up with a solution that's best for your child, but a solution that is also most practical for your child and family. And so you need to take many factors into consideration when you're thinking about what tool. But I guess my parting words would be learn about the tools and try the least restrictive options before you go to a more restrictive option. So thanks. I appreciate this opportunity to talk with you guys, and you know, feel free afterwards to reach out and contact me. My contact information will be on the PowerPoint that will be posted. So, and I wish you well. Thank you.
If no one has any further questions, again, as Barbara mentioned, we will be posting the recording as well as all of the supplementary materials, including this presentation, on our website. That should be up within the next week. And then if anybody has any questions, again, feel free to reach out to us or feel free to reach out to Barbara directly. With that, I just want to thank everyone for joining us, and we'll give you a few minutes back in your day.
Thank you all. Take good care.
Thank you.
Yep. Bye-bye.